Okay, in this video we're going to be discussing some of the provisions of what is known as the Montevideo Rules or the Montevideo Convention on the Rights and Duties of States. This is found as a PDF on our Moodle Canvas page, Moodle Canvas in the Future. This is also in the course handout booklet, Volume 1, on page 76. So this, the Montevideo Convention, or the Montevideo Rules, basically is a codification of the customary rules of international law as it relates to how a state, what the definition is of a sovereign state. It's called the Montevideo four-part test. So let's take a look here, first of all, at Article 1, which is the primary component or article of the Montevideo Rules. Okay, Article 1. Excuse me for a moment there. This is the four-part test under the Montevideo Rules. I have several test questions on this in both the quiz and on the final exam, I think it's on the midterm. So again, you're going to want to bookmark this so you'll have it available so you can refer to the specific articles when you're taking a quiz under quiz 2, and then again on the midterm. So the four-part test. Let me give you some background first. So what we're trying to determine, let's say we have a geographical area, like state of Oregon, right? We have a geographical area. And the question is that area considered a sovereign state for international law purposes? Or is it some other type of political unit, something less than a sovereign state for international law? Now remember, the whole idea of sovereignty is no higher power than the ruling government of that area for international law purposes. So how do we tell if a geographical area, such as let's say the state of Oregon, is a sovereign state for international law? Well, this is how we first look at this test. Does the area have a permanent population? Do people live there on a permanent residential basis? Or, versus nomadic or some other type of movable population? Number 2, does it have a defined territory? That is, borders. Now, the borders may not be, the borders may be in dispute, there may be challenges over the borders, but generally speaking, is there an area that is recognized as being the borders of that state? Letter C, is there a government that has the capability of governing those borders? Now, from a customary historical international law standpoint, this referred to essentially a government which may be historically a warlord or a ruling family or a monarch or a chieftain or an earl or whatever you want to call it. Did that person or that government have the authority or the ability, which basically historically meant both military ability to protect those borders? Now it more or less means, is there a government in place that's functioning, that has the ability to enact law, enforce law domestically within those borders, and that sort of thing? So is there an official government for that area? And then finally, does that area have the capacity to enter into relations with other states? Now, what this basically means is, under the domestic law of that area, is that geographical area given the legal authority to enter into international agreements, treaties, conventions, engage in international relations, and that sort of power or authority? So let's take a look at the state of Oregon. The state of Oregon has a defined border. We have a population. We have a government. We have the governor of the state of Oregon, legislature. We have Oregon State Courts. We have Oregon State Police. We have sheriffs. So we do have a government that controls the area that we know as Oregon within the borders. But Oregon would not be considered a sovereign state in international law because under the United States Constitution, the authority to enter into international law is transferred to the federal government of the United States of America. That is the President, Congress, and the Supreme Court, and all the various agencies we have at the federal level. So Oregon would fail the four-part test as laid out in the Montevideo rules because Oregon does not have the legal capacity to enter into international relations. That is transferred to the federal government. Now, Article 2 basically says that same issue. The federal state shall constitute a sole person in the eyes of international law. So, just to back up, what is a federal form of government? A federal form of government is where you have smaller governments like the United States of America. You have Oregon, California, Florida, Massachusetts, etc., which each have their own government. They have their own authority within their state, but we are a federal form of government in that we have the United States federal government that overrides all of the 50 states. Congress can write law under the Supremacy Clause of the United States Constitution. All states are bound by federal law. If there's a conflict between federal law, it will override state law. So we are a federal form of government. So the federal government has the authority on an international level and is recognized as the state as opposed to individual states. Now, there are federal forms of government throughout the world. In fact, most countries, in essence, are a form of a federal form of government. And so this is essentially confirming the customary rule that the sovereign state for international law purposes is the federal state and not the individual component states that make up that federal form of government. Another example might be Italy. Up until 1860s, Italy was composed of various different city-states, Florence and Naples, and etc. And so the idea was that when Italy became a federal form of government, Italy is the federal form like the United States, which would be the sovereign state for international law purposes. And we see that throughout history, throughout many countries of the world, Germany, etc. Okay, Article 3. We get into some of the other provisions. Whoops. The political existence of the state is independent of recognition by other states. Now, what this basically is referring to, and this is a gray area of law, but there are two ways that a state can be recognized. There are two kind of components to it. The first is what we call recognition by law. That is called de jure recognition. And that basically, de jure means law, and then there's de facto, which means of the fact. And I'll talk about those two terms in a different, as part of our PowerPoints. But this is where we get into the idea, de jure means you are a state if you meet this four-part test. Well, that's fine on paper. But in reality, there's more to a state being a state. Other states basically have to recognize or treat that area as a state. And we see this happen when we talk about independence or splintering of states after, like the fall of the Soviet Union, or you have secession of an area, or decolonialization or independence of a certain area, breaking up of countries. Is it a state or not? So let's say like Oregon decided to secede from the United States of America. The Oregon came up with its own rules that gave it international power, but still it might meet that four-part test, but if other states didn't recognize Oregon, factually, real world, that still wouldn't be a state. It would be sort of in a gray area. All right. Article 4. Article 4 is another codification of international customary law, primarily post-World War I and post-World War II. And this is the idea that we've talked about over and over again, that a state, as a sovereign, states are equal. So Costa Rica, geographically speaking, is a small area versus the United States. The United States has much larger geographical area, much larger economy, etc. So from a legal level, de jure, of the law, Costa Rica and the United States are considered to be equal. This is sort of like equal protection or equality of individuals under the U.S. Constitution. Same idea on an international law basis. From an international law basis, regardless of the geographical or economic size of a state, they're considered equal in the eyes of the law, in court, in treaty making, etc. Now, real world, obviously that's not always true. A larger country that has more economic, political, or military power, factually, real world is different than in terms of meeting that four-part test. Now, where this comes up in a legal context is when you're in court at the United Nations or other treaty-making organizations, states have basically equal authority depending on how it's structured. And we'll talk more about that in other lectures. All right. Article 7. The recognition of a state may be express or tacit. So, what that means in plain English, as we will talk about in other lectures and other materials in the class, recognition of a state, that is, whether or not other states consider that geographical area to be an international sovereign. That can be done in various ways. Express basically means a state in writing or verbally through the president or prime minister or whatever says, we formally recognize this area as a sovereign state now. That's express. That's done occasionally. It's a form of international diplomacy in many ways. And so let's say we have a newly formed state after a breakup of a previous sovereign. Let's say it breaks into three parts. And the United States President would say, we recognize the three individual areas now as separate sovereign states. That would be express recognition. Tacit means recognition through conduct. Not done specifically, but by conduct. So probably the best example I could give you of tacit recognition would be, let's say again we have a state that breaks into three parts, and the United States goes to each of those three new countries and enters into a treaty with each of them, but does not expressly recognize them in a formal document. But by entering into a treaty, that is a form of recognition impliedly. So the idea being, only a state can enter into a treaty, thereby if a state enters into a treaty with another newly formed state, that is recognition of that state, that new state, as being a sovereign. Expressly, as you actually say it. Tacit, impliedly, means your conduct bolsters the idea that that area is now a formal sovereign international state. No state has the right to intervene under Article 8. No state has the right to intervene in the internal or external affairs of another. This is going back to the idea that as a sovereign state, you're juridically equal, and therefore other states should not be interfering. That goes back to the idea of sovereignty. This is just a codification of that rule. Article 9, the jurisdiction of states within the limits of national territory applies to all the inhabitants. This is basically a codification of the idea that the domestic law of a state is applied internally and not necessarily internationally. And then finally, Article 10, the primary interest of states is the conservation of peace. And again, this is the idea of moving from rule of force to rule of law. And getting away from the historical idea of force, military, economic, etc., being the primary driver of international law. So when I refer to the Montevideo rules, this is the Montevideo rules or the Montevideo Convention. This is what I'm referring to. Now, Again, this is based on codification of customary international law. Now, here's kind of an interesting historical component to this. Notice when this came into force. December 26, 1933, Montevideo, entered into force 1934. This is pre-World War I, or excuse me, pre-World War II, right? So, interestingly enough, you know, when Germany took over various different territories post-World War I, leading up to World War II, essentially many of these rules were violated, right? But this nowadays is what we refer to as the Montevideo rules, which lead to the definition of what is the legal four-part de jure definition of a state, and this puts those customary rules into a form of a convention or codification. Okay, that will be the conclusion of this video involving the Montevideo rules on rights and duties of states.